Wike urges Nigerians to stay calm amid economic challenges. Hello viewers and welcome to InfoGist TV. The Minister of the Federal Capital Territory, Nyesom Wike, has called on Nigerians to remain calm and patient in light of the current economic difficulties the country is facing. Speaking in Ibadan during a condolence visit he paid to the governor of Oyo State, Seyi Makinde, over the death of his older brother, Engineer Sunday Makinde, Wike emphasized that the policies being implemented by President Bola Ahmed Tinubu are fundamentally aimed at the betterment of the nation. Wike asserted, in his words, I have always told people to be patient. With this government, this country has faced significant challenges in the past, and it isn't essential to recognize the progress we have made. Nigerians often forget where we were and the efforts being put in place to improve our situation. The minister, in company of the former governor of Benue State, Samuel Otom, other dignitaries urged the public to understand that while the transition may be painful, it is necessary for long-term benefits. There is no such thing as a miracle solution. The policies Mr. President is enacting are designed to benefit all Nigerians. Although we may have to endure some hardship now, we should not panic. Mr. President genuinely cares for our country, and I assure you that better days are ahead. Commiserating with the Makinde's family, Wike expressed deep condolences and emphasized the importance of unity in times of grief. He shared heartfelt words of support, assuring them that they are not alone in their sorrow and that their friends stand with them during this difficult period. In this moment of profound loss, we are here to offer our love and solidarity, he said. Meanwhile, the People's Democratic Party, PDP, is now ready to take disciplinary actions against some of its members, including the former governor of Rivers State and Minister of the Federal Capital Territory, Nyesom Wike, the Ulster PDP National Secretary, Senator Samuel Anyanwu, the former governor of Benue State, Samuel Utom, and others over alleged allegations of anti-party activities and assault on party members. While Wike and Utom are facing charges of working against the party in elections and making distasteful public comments against the party, Anyanwu is reportedly facing allegations of violations of party constitution, disregard and disrespect of the party organs, condoning thuggery and assault of party members at the party secretariat, which has brought the party to public derision. The 26-member disciplinary committee, headed by the former Minister of Foreign Affairs Chief Tom Ekimi, has scheduled Wednesday, February 12, 2025, to deliberate on all the petitions submitted to it regarding the above charges by party members and leaders. According to a letter made available to the public by the Ekimi-led committee, the panel is set to hold its first meeting with the affected individuals and take the necessary disciplinary actions against them. This action is part of a broader effort by the People's Democratic Party (PDP) to find lasting solutions to its internal crisis. Anyanwu is embroiled in a stiff contest with Honorable SKE Ude Okoye, who was declared the PDP National Secretary by the Court of Appeal, a situation which degenerated into physical attack on Ude Okoye at the PDP National Secretariat by talks said to be loyal to Anyanwu had also pitched Anyanwu in verbal attacks against the People Democratic Party governors and Board of Trustees for affirming Ude Okoye as the National Secretary of the party. Also, this is coming after the appeal court has denied Senator Samuel Anyanwu, the Ulster National Secretary of the People's Democratic Party (PDP's) request for a stay of execution regarding the December 20, 2024 judgment. This decision means that Senator Samuel Nemeka Anyanwu cannot temporarily suspend the execution of the December 20, 2024 judgment that sacked him and affirmed Right Honorable Ude Okoye while his appeal is being heard. In other words, Senator Samuel Anyanwu is not legally eligible and qualified to occupy the office of the National Secretary of the party until his appeal at the Supreme Court is heard and decided upon. In Nigerian law, a stay of execution is an order by a court to temporarily suspend another court order or judgment. To obtain a stay of execution, an applicant must demonstrate special and exceptional circumstances showing that the balance of justice weighs in favor of a stay. The court's decision suggests that Anyanwu failed to meet these requirements. The court may have considered factors such as the potential impact of the stay on the parties involved, the likelihood of success on appeal, and the need to prevent injustice and irreparable harm. It's worth noting that an appeal itself does not automatically operate as a stay of execution. Instead, the applicant must make a separate request to the court. On the other hand, A federal high court in Abuja on Wednesday dismissed an application filed by David Ukpo seeking an order setting aside the July 1st and 6, 2022 orders for the release of his biodata to Senator Ike Ekweremadu in a UK court. Justice Inyang Ekwo, in a ruling, held that the applicant, the Edo Civil Society Organization that filed the motion on Ukpo's behalf, lacked the legal right to institute the case. Justice Ekwo held that the provisions of Article 3 sub E of the preamble of the Fundamental Right Enforcement Procedure Rules 2009, under which the Edo School filed the suit, cannot be said to have granted any person without legal personality to sue or be sued in court. It is the avowment of counsel representing the applicant, Bamidele Uche Ibenedion Esquire, that he is one of the lawyers in the law firm of Dele Ibenedion Chambers, that this application is to protect the applicant's human rights upon being instructed by Edo Civil Society Organization on behalf of the applicant. Going by this environment, it is clear that the applicant, in this case in Edo Civil Society Organization, Edo School, the counsel for the applicant knows this but cleverly avoided to state so on the face of the application and rather deposed to this fact in the affidavit in support. He said the News Agency of Nigeria reports that Edo School, on behalf of Ekpo, had filed a motion and notice brought pursuant to Order 14 Rules 10, 26 Rules 1 and 2, Rule 1 and 34 Rules 4 and 7, Sub 2A of the Federal High Court Civil Procedure Rules 2019 and Section 36 Sub 1 and 37 of the 1999 Constitution, and under the inherent jurisdiction of the court. The applicant sought an order setting aside the proceedings and the rulings delivered by the court on July 1st, 2022 in suit numbers FHC ABJ CS 984-2022. He also sought an order setting aside the proceedings and the order of court made on July 6th, 2022. He equally sought an order of perpetual injunction restraining Ekweremadu and his wife Beatrice, and the first to fifth respondents or any other person, however described, acting for the Attorney General of the Federation, from executing or further executing the July 2022 rulings delivered on July 1st and 6th, 2022. Alternatively, the applicant prayed the court to bar them from breaching or further breaching Ekpo's rights to privacy guaranteed by Section 37 of the 1999 Constitution. But Ekweremadu and Beatrice, through their counsel chief Adeboyega Awomolo SAN, urged the court to dismiss the application. They argued that Ekpo, who was taken to the UK sometime in 2022, could not have briefed anyone as his whereabouts was unknown. Besides, they argued that there was nothing before the court to show that the said minor, Ukpo, briefed Edo School. Citing previous cases to back the argument, they submitted that those cases cited did not deal with a situation where a third party purportedly instructs the counsel to appear for them in a suit. In this case, the applicant on record did not instruct anyone, but rather it was Edo School, a third party, that instructed counsel, as has been revealed in their affidavit in support, which is an issue before the court decided. NAN reports that Justice Ekwo had, on July 1st, 2022, ordered the National Identification Management Commission, Controller General of Nigerian Immigration Services, Stanbic IBTC Bank, United Bank for Nigeria, and the Nigerian Interbank Settlement System PLC, first to fifth responded respectively, to release Ukpo's biodata to the Ekweremadus in the UK court. The judge ordered that all information, including his bank verification number, should be released for Ekweremadu's defense in the UK court over alleged organ harvesting. Justice Ekwo had, on July 6, 2022, directed the NIMC to immediately release the biodata of Ekwo to the Attorney General of the Federation for onward transmission to the UK court. The court issued the order following a request to that effect by the NIMC, and in response to the request of the convicted couple to defend themselves in a London court, the order followed the name's refusal to obey the earlier order of court. Ekweremadu and wife had, in the application dated and filed June 27, 2022 by Awomolo, dragged the respondent to court. The couple were, on June 23, 2022, remanded in the UK police custody after they were arraigned before the Umbridge Magistrate Court for alleged conspiracy to facilitate the travel of Ukpo, alleged to be a minor, for an organ harvesting. Despite their denial, Ekweremadu and his wife were convicted and sentenced to prison in May 2023, while Ekweremadu was sentenced to 9 years imprisonment for organ trafficking. His wife was slammed with 4 years and 6 months jail terms. The medical doctor, Obinna Obete, who was said to have conspired with them, got 10 years imprisonment. Meanwhile, Ekweremadu's wife was in January released from the UK prison after serving her jail terms. Delivering the ruling, Justice Ekwo agreed with the argument of Ekweremadu's that the prayers on the face of the motion paper were not prayers for the enforcement of fundamental rights. Council cannot be allowed to file what he pleases and attempt to bring same under a sui generis procedure. If the applicant was interested in enforcing his fundamental rights, Council ought to have instituted a fresh action under the Fundamental Rights Enforcement Procedure Rules 2009, he said. The judge said that the prayers on the motion paper had become academic and do not require any answer, nor can the court grant same. The information required for which this court gave order has been utilized as respondent/applicant Diekwe Madu stood trial and were convicted in May 2023, he stated.